This courtroom session starts off routine, but don't get comfortable. Within minutes, we're seeing questionable dismissals, unexpected leniency, and then a case that completely spirals into confusion, contradictions, and a judge who is clearly not having it. From bond violations to possible wrongful charges, every moment here raises serious questions about accountability and fairness. Stay with us, because what unfolds next is a mix of legal complexity, human error, and one defendant whose explanation might not hold up under pressure.
Just to let you know, on that no insurance, if I'm looking correctly, there is a suspension on that.
You're gonna have to pay that to get the suspension lifted from your. I mean, frankly, I'm surprised he's dismissing it, but I'm not gonna quarrel about it. But you're gonna have to pay the clearance fee on that, okay? It's $45. Anything, you still wish to waive your right to a lawyer?
Yes.
Anything you'd like to say before I sentence you?
No.
100 fines, 200 costs, 75 victims' rights, $50 justice assessment, 4.25 or 60 days. And then you're gonna apply that. You're gonna apply the 45 for the clearance fee, so that's 480. I'm sorry, 470. And then the other money is going to be sent, we have to send it to your husband, okay? And we'll go from there. They'll explain everything to you down there. I sincerely wish you well. Good luck. Paul Edward Fortuna.
Right here, we're seeing a pretty interesting legal moment. The judge openly admits surprise that one of the charges specifically tied to no insurances being dismissed. That's not something you hear every day in court. Typically, these types of infractions carry consequences, especially when tied to license suspensions. But despite that, the defendant still walks away with multiple financial penalties, fines, court costs, and a clearance fee to reinstate their status. So while it may look like a win on paper, financially, it's still a burden. What do you think, fair outcome? Or too lenient?
Yes. Mr. If you're ready with something, tell me which ones. I'll call them. Come on up here, Mr. Fortuna. 25W840-237. Which cases do you have today?
Molinari.
What else? What else?
Prince.
Molinari and Prince? All right, go be next. Sir, your name?
Paul Fortuna.
You're charged with drunk driving, OWI. You have the right to a lawyer. Would you like a lawyer?
Yes, please.
We'll give you a lawyer. You go out in the hallway.
Thank you.
And he's gonna set you up. My court officer is with an attorney, okay? Janaya, Amani, Ariane, G. Neely, 25W839-8298 and B and C.
Now this is where the tone shifts. When someone is charged with drunk driving, the court immediately emphasizes the right to legal representation. And for good reason. DUI cases can carry serious consequences, including jail time, license suspension, and long-term impact on someone's record. Notice how the judge doesn't even hesitate. He strongly suggests getting a lawyer. That alone tells you how high the stakes are. If you were in this situation, would you try to handle it yourself, or take the court's advice and bring in legal help?
D. Come on up here, ma'am. So the other files were taken down. Your brother didn't show up. You're charged with driving on a suspended, operating while intoxicated, and open intox. Your name? You have the right to a lawyer. Do you want one? You should get one on a drunk driving.
Yes.
Okay. John, set her up with a lawyer. Molinari, Madison Gabriel, Molinari, 24W8355562. Your name?
Madison Molinari.
Okay, so you went through probation. You're all set. Your name?
Madison Molinari.
Raise your right hand. You solemnly swear affirm on the penalties of perjury, the testimony you've given these proceedings will be the whole true self you got.
I do.
Technically, his, what do I say? His representation ceased at the time of the sentencing. Since you were in court on January 22nd, have you been arrested?
No.
Any new charges?
No.
Any contact with the police?
No.
Defendant compliant, case dismissed. Congratulations to you on motion of the prosecutor. This was technically your representation ceased at the time of the sentence.
Sure.
I'm gonna go ahead and dismiss the case. We're all set. You're all set. Good luck.
Thank you.
Prince, Kevin, Jaron, Darrell Prince.
This is actually one of the rare positive moments in the courtroom. The defendant followed all conditions. No new charges, no police contact, full compliance, and as a result, the case gets dismissed. That's the system working exactly how it's supposed to. It shows that if someone takes probation seriously and stays out of trouble, there's a real path to walking away clean. But let's be honest, how often do we actually see outcomes like this compared to everything else going on today?
25B-726-159. Mr. Prince, come on up here.
Mr. Prince, this, please make it correct.
Did he sign an advice of rights?
Today. It's for sentencing and,
This is for a sentencing?
yeah, sentencing, there's a bond violation, allegations of a bond violation also, but this is.
I didn't even see this file. My apologies. I thought it was just a probation violation.
No, it's bond, alleged bond violation.
So I ordered him to test that day. Okay. Who's his probation officer, Ms. Tessino?
Yes, John.
My mistake. I saw the,
Hello?
I need John Kevin Prince in here, okay?
Okay, I'll be in a second.
Thank you.
Yep.
So, hang on. Mr. Tessino swore to bond violation I wrote on December 22nd. Defendant did not appear for testing as ordered on December 16th. On December 16th, I found him guilty of violating the bond and ordered him to test that day. Mr. Prince didn't think he had to test apparently. That's what I'm reading out of it. So we got a big problem, massive, huge. I don't know what he's thinking. So I'll listen to whatever you have to say. I'm going to sentence him on the bond violation. I'll determine how I'm going to proceed, and we will go from there.
And here's where things start heating up. The judge is clearly frustrated, and you can hear it in his tone. Massive, huge problem. Missing a court-ordered test isn't a small issue. It's a direct violation of a judge's order, which can lead to serious consequences, including jail time. At this point, the courtroom dynamic shifts from procedural to confrontational. The real question now is, was this a genuine mistake or a weak excuse?
Wait for Ms.
I don't need to wait. I see what happened now. He violated my order.
Well, Your Honor, it's.
What happened? Did he get run over by a truck? Did he have a heart attack? Why didn't he go test on December 16th?
He would have came timely, however, he held up very close here by the train. It's not an excuse, it's just what happened. He doesn't, he's just, he now knows he needs to come a little early. I told him we have a interesting train schedule around here, but he needs to not cut it so close.
Do I look stupid?
No, Your Honor.
I must. I often question how stupid I must look. Your name? I want to make sure I understand this. There has to be, I must be misunderstanding. You swore out a bond violation. He came in front of me. I found him guilty of violating the bond condition. I ordered him to test on December 16th and he didn't test. Is that true or false?
That is true, but he does have an explanation.
What's the explanation? Forgot about, he told me, his lawyer just told me he got stuck by a train.
That is the explanation he provided me as well. He emailed me. It was a train, but I also, sounds like there was some confusion with the testing times in the evening.
How?
That he thought they were later than they were, and they're just from 5 to 7.
And I believe he's supplied at least some pictures to show that he was at least physically in that area trying to get here.
Yeah, he did email me. I didn't print the email. I should have printed it. He did email me, but and I explained to him that nonetheless he missed the test, and then his next test wasn't until December
22nd.
18th.
Now we're getting into the defendant's explanation. And honestly, it's not landing well. The infamous stuck by a train excuse comes into play, but the judge immediately starts picking it apart. Timing issues, testing windows, location inconsistencies, it's all being scrutinized in real time. In court, details matter. Even a small inconsistency can destroy credibility. So ask yourself, does this sound like bad luck or poor planning?
My client would submit that if he would have tested right now, he would test negative.
Yeah, I know, but that doesn't tell me anything.
Understand. It's a snapshot of where he's at.
Go get the email. What train? I can't hear you.
You want no Van Dorn?
Van Horn?
Yes.
One right out here.
Yes.
You live in Flat Rock.
Yes.
Why'd you have to come from the north?
We came from Van Horn coming east. So I
Van Horn coming east.
stuck after I-75.
Slow down. Where were you coming from? Flat Rock?
Yes.
All right. The train is north of Van Horn.
Yes.
Why would you have needed to drive north of Van Horn instead of turning right on eastbound Allen and turning into the courthouse?
I got to come on the other side.
I can't hear you.
I come from the other side of Telegraph, so I take Van Horn from Telegraph. I'm all the way here. So the direction from Van Horn.
I thought you said you just got stopped here on Van Horn.
Van Horn on the other side of Allen Road, coming from I-75, coming towards this courtroom.
I never dealt with this case at all. You know that? I never had any of this case before me, ever. Except on the bond violation. What time did you leave?
I left here
No, not here. What time did you leave to go test the DNA?
6:30 p.m.
What time's DNA open?
From 6:30 a.m. to 9 a.m. and then again 5 to 7 p.m. So he emailed me on the 16th at 7:32 p.m. and said, been here for 15 minutes, and he did provide 2 pictures of the train, but DNA was already closed. And then I emailed him telling him I was confused, and he said, sorry, I meant to send an explanation with the pictures. Yesterday after court, I went straight to go drop like the judge asked, but DNA was closed around noon, which would be true. They're open 6:30 to 9 p.m. And he said then I had to be to work around 1:30 p.m. I planned to go after work that day, but I had got stuck by the train again, and by the time I was able to get around to DNA, it was closed again. And he put in parentheses, I thought it was open till 9 p.m. So I had planned on going this morning, and when I called the DNA number, no callers were called, which was accurate. DNA wasn't open that day.
Where's the picture? Can you tell where the picture is taken on what track?
It's black and white, and even on, I don't know if he has the picture, it looks,
Let me see.
it's hard to see, and it's dark, so that doesn't really help.
Well,
He lives on West Huron River Drive, right?
That's where I stay. Yes.
I can't tell, make heads or tails out of this.
My client and I both understand frustration with what seems like.
He had a 461.
My client understands he's got a drinking problem.
Does he live in Flat Rock?
Yes.
Did anybody talk to him about sobriety court?
They have. I'm just looking forward, if we would get to the sentencing, to joining the sobriety court. It's been approved. He's ready
He's
to
a
go.
candidate.
He's a,
He was scheduled for sentencing today. He was the email, the vote email, he was on there, and for whatever reason, everyone responded to both, and you only responded.
well, because this was not put down as my case.
So
I don't know what happened. This is what I'm talking. There's just too many mistakes.
well,
This was listed as Judge Hessen's case. This is not Judge Hessen's case. She took the plea in my absence. I've never seen Mr. Prince, except for the bond violation hearing. I've never talked to Mr. Prince. Have you been at any of the status reviews that I've had?
yeah, he missed this morning. I was just thinking about it.
Well, when was he at a status review? The plea was taken on November.
Well, there wasn't, he would have been, I believe, he didn't have one in December because of the holiday, so he would have been probably at one before the holiday.
Were you at a status review with me?
No.
It's never even been at a status review. I didn't know who he was, and they said it was Judge Hessen's case. I had no reason to
Can I
quarrel with.
explain that? So he was on probation with Judge Hessen for a separate OWI. It was in warrant status, if I remember correctly, she revoked the probation. You were off that day, that's why she arraigned him and referred him to you. This case.
No, I know, this was my case.
Yeah.
She took it in my absence. I don't know where I was on that day, but she took it in my absence. I get it. I'm not
Yeah.
quarreling with that. But no, but I was I'm not voting on who's gonna be accepted into Judge Hessen's sobriety court or not. And I was told this was her case. I don't remember this. I mean, if I was that good at remembering every face that came in front of me on every case that I ever handled, I have no business being here. I should have been present. Give me a break. Here's what I'm doing. What's that?
He was referred for your sobriety court on the new case.
I know that,
Okay,
but I've never talked to the man. I didn't take his plea. I never saw him at a status review. The email sent out said that it was Judge Hessen's, and I wasn't gonna vote on it since it was Judge Hessen's case. Here's what I'm doing. I need to back up on this. I'm not doing anything right now. I'm gonna adjourn the sentencing for a couple weeks. And I'm gonna take a look at everything. I didn't even read anything on this because I did not believe it to be my case. So I will adjourn this 2 weeks.
This might be one of the most revealing moments of the entire session. The judge openly admits he didn't even realize this was his case. That's a serious procedural breakdown. Miscommunication between courts, judges, and documentation can create real legal risks, not just confusion, but potentially unfair outcomes. Instead of rushing a decision, though, the judge does something important. He pauses everything. This is actually a strong example of judicial responsibility. Better to delay than make a wrong call.
I'll adjourn the sentencing. Are you here on the 21st? Well, I'm not here. Heather, I need you to give me another date, please, for a sentencing.
That'll be February 4th at 9 o'clock.
Sorry, I gotta go all the way to February 4th at 9 a.m. But I just do. I didn't even read the report. I don't even remember seeing this blue back in my file today.
it
Maybe,
did that, I will say, because of bond violation, I brought it down to Sadie this morning. So
yes.
I will say,
So
but
I didn't see the report.
I understand the confusion with the email.
I'm putting this back. That's what I'm doing. He's to remain, and then I'll decide when I talk to the other people in you or whoever else. I'll decide what I'm gonna do on this, but I can't. You're gonna have to go down the hall and get another date, sir. I'm sorry.
Fair enough.
You understand? All right, thank you.
Thank you.
Johnny Thornsberry. Jeremy Christian, Antonio Robertson, 25W8376064. Your appearance?
Good morning, Your Honor. Peter Granada, P78413 LNAC, representing Mr. Roberts.
Your name?
Cheers. Roberts.
So he stole something, he's gonna plead him to disorderly.
Disorder.
There's $1,146 that he stole?
Yeah, Your Honor, if I could explain that.
Yeah, I can't wait to hear.
Your
It should be a
Honor,
felony.
Your Honor, Mr. Robertson is a barber, and one of his clients, who he had only cut his hair one time, asked him for help to go to Lowe's to basically bring some building materials from Lowe's
to a building site because he knew he had a pickup truck. So he agreed to help his friend out. Went into the store with him. They collected whatever materials they were. His client, everything that was on both his cart and his client's cart was scanned through. But unbeknownst to Mr. Robertson, the card was declined. And since it was a self-checkout and
Hang on a
the
second.
person wasn't actually watching what was going on, his client gave him the nod that everything was okay, and then he went out and loaded the stuff.
So he didn't
dropped the
intend
material
he didn't
off.
intend to participate in it.
Correct. And then he dropped
Well,
material
then the
off.
prosecutor needs to revisit this. He shouldn't be convicted of spitting on the sidewalk. I don't care what it is, if he didn't participate intentionally in a retail fraud or a larceny, and that's what it sounds like. So you better go talk to the prosecutor again. If we have to, we'll set it for trial or another pretrial, but I can't take a plea even to disorder if he's saying he didn't do anything wrong.
He, again.
That's fine.
The video and the photographs show.
Well, then
Basically, just what I
the
said.
criminal justice system is terrible if we're having him plead guilty to something and he didn't do anything wrong intentionally. He still has to intend to steal, right?
Can I suggest?
This is a powerful moment. The judge refuses to accept a plea deal because the defendant claims he didn't intentionally commit a crime. That's critical intent is a key element in many criminal charges. If there's no intent, there may be no crime. The judge even challenges the system itself, saying it would be wrong to convict someone who didn't knowingly do anything illegal. That's a rare but important stance. Do you think more judges should push back like this?
Ask if we can set this for another pre.
Yeah, I'll do that. I'll do that.
Then that'll give me a chance to actually, because he had the video on a disc, but I had to look over the shoulder of the detective to watch it. I didn't actually get
Hey,
time to watch it.
you don't have to explain to me. I'll adjourn this for another pretrial. Wait a minute, how many times are we gonna adjourn this? Where
So
you?
there was a council issue last time, Your Honor, with Attorney
Yeah,
Crawford.
but he didn't show up July 23, he didn't show up on August the 6th. I'm setting it for either jury or bench and a final pretrial.
Final pretrial.
Is. Heather, I think I can do this one on the 28th at 8:30, can I? That's what I'm gonna do. October the 28th at 8:30. Are you here that day?
Yes.
Okay, that's what I'll do. Was that all right, Heather, or somebody gonna get mad?
Okay. No, we could probably get that done at 8:30.
Just make sure everybody's here at 8:30 that day. If it doesn't resolve, I'm setting it for trial.
I understand, but again, we're gonna come back on 1/20.
Correct.
January 28th. Okay.
You can talk to him further, but I can't take a plea if he's saying he was duped into stealing
Well,
something.
since I actually after I met with the prosecutor and I talked to my client, and actually we had now a name of the individual that.
Good, maybe you can turn it over to the police sooner
that's
rather
what I'm
than later.
I've got more wiggle room now with the prosecutor than I did before.
Okay, good enough. We'll see you here then.
All right.
Good luck. Go down the hall and get your handwritten notice. Thank you.
Mr. Thornton, he's approaching.
Your name, sir?
Johnny Alphonse Green.
This is possession of cocaine, right?
Correct, Your Honor.
He stands mute, waives formal reading.
Correct, Your Honor.
Does he have any prior drug offenses?
No,
This says that he's going to plead guilty.
the 7411, yes, Your Honor.
Yet another one right after this in Lincoln Park, it looks like.
Yes.
If you plead guilty here to possession of cocaine, I'll take this under 7411. Possible penalties, they're charging under local ordinances up to 500 fines, 90 days jail, costs of all those. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you will be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
Any questions? To the charge, possession of a controlled substance, specifically cocaine, how do you plead?
Good.
On November 14 of 25, were you in the city of Woodhaven, County of Wayne?
Yes.
And were you specifically at West and Gudith at 1:43 in the morning in Woodhaven on that date? And were you in possession of cocaine?
Yes, sir.
Was it in a vehicle, on your person, what?
If you-
And were you driving the vehicle?
Yes, sir.
Were you by yourself?
Yes, sir.
Where was the cocaine in the vehicle?
It was sitting under the armrest.
And you knew it was there?
Yes, sir.
It was your cocaine?
Yes, sir.
Are you on probation or parole?
No, sir.
Anybody force you to plead guilty?
No, sir.
Please accept it to that charge. I'll take it under 7411. I'm going to refer him for a screening and assessment. I'm going to give you a $2,000 personal bond. You cannot leave the state without the consent of the court. You cannot violate any law. You must appear in court as directed. Do you understand all of that?
Yes, sir.
Also, I want you to understand, you are going to go over to the Woodhaven Police Department by 2 p.m. today to get fingerprinted and photographed. That is a condition of your bond. You understand that?
Yes.
You're going to be screened and assessed today. You're going to fill out a questionnaire and be interviewed as soon as you leave the court. First, you'll go down and get your notice of your court date. Then you'll come back over to probation. You are going to undergo a screening and assessment. You're going to go to AANA at least 3 times a week. You are going to test weekly. So I just want you to be aware you're to test weekly, and they're going to set you up with testing. So you're going to be tested weekly. You're going to go over there. You are going to be tested weekly. They'll set you up. They'll give you a color every time you go. We will receive the results, and you're not to purchase, possess, or consume alcohol, marijuana, or illegal drugs. So weekly testing, no marijuana, no alcohol, no illegal drugs, in person, AA, screening and assessment, test weekly. I'm going to give you a sentence date, and that will be in this case on,
It'll be February 4th at 9:15.
okay, February the 4th at 9:15. Okay,
Thank you, man.
do you understand everything? You got to get off of this stuff.
I just got out of.
I don't want you to talk, okay, good, show them that, but I don't want you to talk about the case, but it scares me that 11 days later you were getting picked up. Don't even mention it. Don't talk about it. Good luck. Daryl King Jr., 25G 306 414 21T 636 962 A and B. And
This courtroom session gave us everything from routine fines to major legal confusion, and from accountability to second chances. We saw how missing a single requirement can spiral into a major issue, how miscommunication inside the system can delay justice, and how one judge's decision can protect someone from an unfair outcome. At the end of the day, this wasn't just about lit, it was about judgment, responsibility, and fairness. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.